Senator Pate on debate.
Thank you, Mr. Speaker. Honourable Senators, I rise today to speak in support of Senator Simon's amendment requiring parliamentary review of the orders in Council under Part 7 of this bill. When contemplating the powers conferred in this bill, we should ask ourselves some very simple questions. How could a government abuse this power to cancel entire categories of immigration documents or applications by order in Council? What might happen if, at mere political whim, thousands of people could be stripped of their ability to work or their right to remain in this country through broad executive orders? We need not look far to imagine a government that might make those decisions without meaningful notice, without moral or principled reasons, and without any opportunity for entire groups of people affected to be heard. These are not hypothetical concerns. These are the powers being authorized in this bill. The Canadian Civil Liberties Association reminded members of the Associate Committee that the Charter is very clear about what is required when state action can cause the loss of lawful status, family separation, and possible removal from Canada. These are precisely the kinds of consequences that engage Section 7 of our Charter. When liberty and security of the person are at stake, the Constitution requires, not suggests, requires procedural fairness. Part 7 of this bill provides none of these protections. There is no requirement to notify those affected in advance, no guarantee of individualized consideration, no meaningful oversight. This type of unbound discretion is precisely what Section 7 of our Charter was meant to constrain. Other witnesses echoed those concerns. The Canadian Union of Public Employees described these provisions as granting Cabinet the extraordinary power to suspend or terminate visa applications and cancel immigration documents en masse under the vague banner of the public interest. It is a phrase that appears repeatedly in this bill, yet it is defined so broadly as to be near meaningless. It includes administrative errors, fraud, public health, public safety, or national security. But those terms can capture almost anything. The International Civil Liberties Monitoring Group cautioned that governments have historically invoked public safety and national security to justify policies that target entire populations, sometimes by nationality, sometimes by religion, sometimes by political belief. And while you may trust this government to not misuse the powers set out in C-12, that is not the point. Legislation should not be written with the governments we trust in mind. It should be written at the very least to be cognizant of, if not actually and specifically, be written for the governments we fear. Just south of the border, we are witnessing a government that exploits legal technicalities and stretches broad interpretations to their limit. The Canadian Bar Association drew our attention to the difference between the way this bill is being marketed and the way it is written. As she pointed out, Minister Diab has suggested these powers would only be used in exceptional circumstances, things like war, pandemic, or mass fraud. Yet when you read the text of the legislation, those limits do not appear anywhere. All the lawyers and legal experts who appeared before SOCI said that nothing in the bill prevents these powers from being used more broadly. Even Tara Lang, the Director General of Integrity Policy and Programs at IRC, said, and I quote, "All of that, the cancellation powers, would be covered under the Order in Council and would explain how operationally this would happen. Again, it wouldn't be without a good reason, and the intent is not to harm your average person in Canada," end quote. Absent legal guardrails, it should be no comfort to any of us to merely hear that the intent is not to harm the people of Canada. Of course, that should be a given. But current global as well as historical realities that many have already discussed should provide us all with cause for pause. It is very clear that categorical decisions affecting entire groups of people will harm average Canadians. And while this government may not intend harm with C-12, we are giving any government, current or future, ample power to exert that harm. When Parliament grants extraordinary authority to the Executive, it is our responsibility to ensure there are accountability measures in place. Senator Simon's amendment does not prevent the government from acting in extraordinary circumstances. It simply ensures that when those powers are exercised, Parliament retains power as a check on the government. The consequences of these orders are not minor inconveniences for the people who will be targeted or incidentally impacted. This is about people's status, their jobs, their families, and their safety. Too often, when government asks for efficiency, it comes at a cost to people with the least power to protect or defend themselves. Today, that cost will be borne by migrants, refugees, temporary workers, students, and even permanent residents. It will likely come as no surprise to you or Canadians writ large that I oppose any system where decisions affecting liberty and security of the person can be made opaquely and quickly. Barring the deletion of this section, I urge us all to insist that these decisions be subject to parliamentary restraint. If we are to acquiesce in the granting of these sweeping powers, we must insist on some modicum of oversight. This is necessary to safeguard the rule of law as well as the rights of the minorities most affected, those who we, as senators and this place, have a particular duty to protect. And with her permission, I will conclude with the words posed to me and the question posed to me by Ms. Esma Bastas. Esma is a legislative intern in our office. Esma asks, I crossed the U.S.-Canada border seeking protection 9 years ago, originally coming from the Middle East. The opportunity to have my case heard in Canada ultimately allowed me to rebuild my life here. I'm now finishing law school in 2 months. It's a small example of how the design of a refugee system can shape whether people are able to access safety and contribute to this community. Please clarify why a bill framed around border security, organized crime, and fentanyl is also restructuring refugee eligibility in ways that risk casting asylum seekers as threats rather than as people seeking protection. I find it difficult to answer Esma's question with this bill. Dear colleagues, I hope you stand up for those who do not have a voice in this process or in this place and support this amendment. Miigwech, merci, thank you.